The worst type of entity for your rental real estate is corporations. C corporations and S corporations are both very bad if you're holding rental real estate. Why is it so bad to hold rental properties in S corporations? There are a couple reasons why. First, S corporations are treated differently than LLCs for tax purposes. And there's a thing called basis limitations when it comes to S corporations. What that means is when you have an S corporation that invests in leveraged assets, by leverage we just mean debt, there's bank financing on it. So when you invest in leveraged real estate, oftentimes, even if you're able to create tax losses from strategies like depreciation and cost segregation, when it ends up on your personal tax return, you might be unable to use those tax benefits because you don't have enough basis. Basis just means that the loss that's generated from your S corporation are not losses from the money you put in or the profits that are generated. So if the loss is coming from other people's money, for example, the bank lending money on it, then you are oftentimes limited in terms of what you can utilize on your personal tax return. This is true even if you're a real estate professional. So we've come across investors who spend a lot of time earning their real estate professional status only to later find out that they still can't use the losses because they've held their rentals in S corporations and they're limited based on their basis. The other problem that we frequently see with respect to people owning rental real estate in S corporations is with respect to finance or refinance. Oftentimes, a lender would require you to move a property out into your personal name to refinance on a loan. And that's typically okay if you have an LLC where you need to move the property out. But if you have an S corporation that holds your rental real estate, just by retitling that property from the S corp to your personal name is actually a taxable event. And it's actually taxable at fair market value. Let's say you bought a rental property for $100,000 and 3 years later, now it's worth $300,000 and you want to refinance to pull some of the cash out. Well, if the lender says I can only refinance in your personal name, then you're going to have to move that property out into retitle to your personal name before you do the refi. And just by simply moving it out, it is shown as a taxable distribution. So it's as if you sold that property for $300,000. If the deemed sales price is $300,000 and my cost basis is $100,000. Now I might have to pay taxes on $200,000 of phantom gain, even though I've never sold the property. This becomes a very significant issue for investors who are trying to maximize their borrowing ability when using an S corporation to hold rental properties. So naturally, the question we get is, what if I already hold my rentals in an S corporation? What are some ways I can rectify this issue? Unfortunately, it's not as simple as it might seem because you can't simply just move title out of the S corporation. That act in itself becomes a taxable problem. So a couple tips though. If you recently bought rental properties or if you have real estate in an S corp that has not appreciated in value, then now might be a good time for you to move it out. Because if I bought it for $100,000, now fair market value is $100,000, then maybe I don't actually have a gain and I can safely move it out of my S corporation. Conversely, if the property has appreciated in value, one thing you might consider is to just wait and monitor. If at some point there's a dip in the market, you can always get an appraisal done. And if the property appraises for a lower value where it's close enough to your original cost basis, then maybe you can move it out with very little or no tax hit. This is one of the reasons why entity planning for tax purposes on rental real estate is very important, because if you have a misstep early on, then sometimes it's very difficult to unwind. We come across new clients all the time who invest several years ago and put all the rentals in S corporations, and those are times where it becomes almost impossible to fix that tax problem. The other thing to understand too is when we talk about S corporations, what we're talking about is the tax designation, because there are also times where an LLC files taxes as an S corporation. So I often come across investors who say, hey, I don't have that problem because my rental is held in an LLC. But if your CPA has chosen for the LLC to file taxes as an S corporation, then you have the same tax problem. Forming an LLC, making sure it is taxed as an LLC or as a partnership or disregarded entity is key. You don't want to hold rentals in any kind of corporation. Rentals belong in LLCs or partnerships. Corporations are usually for more active income. When I meet clients who inadvertently put rentals in S corporations, they tend to ask me, why was I advised of this really terrible strategy? And I think a couple possible reasons. One is maybe the CPA is not well versed in real estate. The other possibility is they don't deal a lot with S corporations. So if the advisor is not well versed in S corp law, then they don't really know what are all the problems that arise when you use it incorrectly. And the third most common reason as to why I see this problem is actually misunderstanding from the perspective of the investor. There are often times where an attorney will recommend an S corporation to be the manager of your entity, but still have an LLC owned title to the property. But if an investor is unclear on that specific strategy, then they turn the rental LLC into an S corp instead of showing those as two distinct and different entities. When it comes to entity formation, there are two considerations. It's the legal aspect of it and also the tax aspect of it. And so it's always a good idea for you to bring your team of advisors together. Instead of you playing telephone between your attorney and your CPA, why not bring everyone to the table on a joint conference call, a joint meeting, or just a joint email so everyone's on board and working towards the ideal structure liability-wise for asset protection and also for tax purposes. If you like this video, make sure to hit the like button and subscribe for more real estate tax strategies.